Thank you, and thank you very much, Gearóid and Shane and Dr. Bracken. Just a few questions for you, Dr. Bracken. You've obviously spent an extensive, much of your career on this particular subject, and you're the author of 2 books that I see. Just one of the questions I want to ask is in relation to one of those, the best interest principle. So, and the same-sex parenting books. So, chapter 6 of your first book examines the allocation of parentage in cases of surrogacy. The chapter seeks to identify a way to regulate surrogacy that adheres to the best interest principle and balances the interests and needs of all stakeholders of the process. It is suggested that the intention-based model of surrogacy, which is facilitated through a pre-conception allocation of parentage, satisfies the requirement of the best interest principle. Would you mind explaining that to us, first of all? Do you want to answer that now? Can you? I'll do them. Is it okay if I do them and they can answer me as a thank you? Could you answer that first? That's the first question to you.
So your question was in relation to the preconception model of parentage, and why I believe that is the most appropriate way forward. So I should clarify that chapter 6 of the book that you mentioned focuses on domestic surrogacy. So I support a preconception allocation of parentage in the context of domestic surrogacy, but in the context of international surrogacy, I believe a post-birth transfer of parentage is probably most appropriate, and I can talk about that later if that is of interest. But in relation to the preconception approach for domestic surrogacy, I do believe that it is the best way forward, really, because it balances the rights of everyone. If you have a post-birth transfer of parentage in a domestic context, it means that when the child is born, the intending parents do not have the legal rights and responsibilities that they need to actually care for the child, despite the fact that they will take physical care of the child very soon after the birth. Instead, typically the surrogate mother is regarded as the legal mother upon the birth of the child, which means she has the rights and responsibilities in relation to making all of the decisions for that child up until the time that a parental order is made. And that's the proposal, or the proposed way that parentage will be transferred in our current AHR Bill 2022. So it means that if, for example, the child needed medical treatment really soon after birth, that it would probably be the surrogate who would need to consent to that rather than the intending parents. And that can place a surrogate in a very uncomfortable position of having to make those kinds of legal decisions on behalf of the child. The bill, I suppose the AHR bill does propose that there will be a transfer of guardianship to the intending parents by way of a statutory declaration with the surrogate after, I believe, the birth of the child. That can alleviate some of those difficulties, but it does seem that there would still be a delay in terms of the intending parents actually getting the legal rights and responsibilities that they need to undertake the caring role. I think it also creates difficulties for the surrogate by being regarded as the legal parent, and it places her perhaps in a vulnerable position. Under the 2017 general scheme, it was possible for either a surrogate or the intending parents to make the application for the parental order, which would ultimately transfer parentage to the intending parents. But under the 2022 bill, only the intending parents can make that application. Which is somewhat unusual because I suppose in the very rare situation where the intending parents fail to make the application, the surrogate seems to have no recourse other than potentially just placing the child for adoption. So for all of those reasons, I think that having a model that allocates parental responsibilities based on the intention of everyone involved, which is that the intending parents will raise the child, and having that become effective at the time that the child is born balances the rights of everyone in the way that I've mentioned. It ensures that the child is legally integrated into their family from the moment of birth, and then that the intending parents have all of the legal tools they need to undertake the caring role. And at a time when they're very busy caring for their newborn baby, they don't have to go back to court in order to, facilitate that transfer of parentage. So in that way, I do believe that it balances the rights of all participants in the domestic context, at least.
And also, in relation to the proposed Assisted Human Reproduction Regulatory Authority, or some sort of a state organisation, would you agree with that sort of principle moving forward? Is that something that you'd like to see implemented in this country? I know that in Canada, the AHR federal authority, it was established and its duties would be similar to what we are proposing here in this country, and it ended up getting abolished in 2013, and I think that was for budgetary reasons. But I suppose really, how do you feel about having some sort of a regulatory authority here in this country in relation to surrogacy?
Yeah, I think that a regulatory authority is really important. It's really important that we have a central body that's able to disseminate information in relation to all aspects of AHR, as well as taking on, the various other obligations that are set out in the bill in terms of licensing and so on. But in respect of the dissemination of information, I think that's really important so that everyone in the country is aware of what the AHR legislation actually says. It's a 136-page bill, I think. So having accessible information that comes from an authoritative source within the country is really important. So I do think that having a central authority will be beneficial going forward, and many other countries do have those kinds of authorities in place. For example, in the UK, there is a Human Fertilisation and Embryology Authority, which do very important work in terms of setting the regulations that exist in relation to various types of fertility treatment.
Thank you. My question then to, is it okay? Yeah. To Gearóid, and I have to say I was very touched, and welcome back. I was very touched by your statements last week. I of all the witnesses that were here, I was most touched by yours and the relationship that you had with your surrogate mother, and the relationship that you were encouraging with the surrogate mother, and how you agreed also to allow the birth mother to be on the birth cert. I certainly was I'm very heartened to hear that you agree with that. And, there are many roads to parenthood, absolutely. And as long as children are loved and cared for and feel secure in life, that's all that matters. But, you heard my statement last week, and unfortunately, a lot of exploitation does go on in this particular road to parenthood. And my question is, how can you regulate against the bad actors? We can make rules in this country, but how can we protect the surrogate mothers in other jurisdictions where we're not covered by that legislation, and that mother is not protected by our legislation in that jurisdiction? So that's my question to you, and both of you actually might be able to answer that question. Thank you.
Thank you for your questions. So just, you made a couple of points there. In relation to my comments last week around the birth cert, so in our case, the surrogate mother is listed on our children's birth cert. That's because they were born in the UK, where parental rights cannot be transferred until after the child is born, and therefore the surrogate is legally obliged to be placed on the birth cert. We, as a couple who had children through the UK, could not go through the parental order process that exists there, because in order to do so, you have to be a resident, passport holder, citizen, etc. So we were none of those. And that's the primary reason why the surrogate is listed on the birth cert. Going forward, we would ask you to consider that when surrogacy is the method of conception, that the birth cert issued to the child would actually list its intended parents, the standard birth cert. But we would suggest that if you wish to include the surrogate on the birth cert, that perhaps it could be done through the long form of the birth cert. So that the child can see very clearly the exact method of conception and gestation. I noted your point about the level of exploitation. I mean, we are all in agreement that legislation is the way forward to prevent exploitation. I would dispute that it's extensive, because I don't believe it to be the case. We in Irish Gay Dads, and that's the organisation I'm speaking on behalf of, work primarily through the United States, Canada and the UK, where the surrogacy model is extremely well established and has been in existence for over 30 years. So I'm very much convinced, and Natalie Gamble, a legal expert from the UK, was before this committee only 2 weeks ago, talking about the fact that she's handled 1,500 cases and she has come across about 3 or 4 that caused issues. So I dispute that the level of exploitation is extensive. But I do want to address your point, of course, in relation to bad actors. All of us, when we dream of having a child, want that child's birth story to be as perfect as possible. We want everybody who's a party to the agreement to be acknowledged, to be included, to be protected. As I mentioned last week, no matter how much you regulate medicine, no matter how much you regulate any sector, there will always be bad actors. But all you can do is put together a very stringent framework that ensures that every party enters into the agreement freely, that they give their consent, that they get appropriate legal support, that they get appropriate medical support, independent medical support, that every party, the intended parents, the egg donor and the surrogate, gets psychological support, so that there is no doubt in anybody's mind in relation to what is about to happen, how it's going to happen, what the process will look like. And clearly there has to be, and you touched on this in your questions to Dr. Bracken, some oversight body that regulates all of the players. It would be the EHRA here in Ireland, it would be equivalent bodies in other locations. And I believe that anybody who participates in a surrogacy agreement, a clinic, a legal person, a medical person, has to be regulated and approved by that body. So they are the safeguards. I mean, not legislating actually is only going to increase the possibility for bad actors. Legislating is the way to lock it down to the extent that you can. Thank you for your questions.
Thank you.
Shane, do you want to come in on that?
Just ethical safeguards, maybe, Shane. Just what do you consider what those ethical safeguards might be for the surrogate mother?
Thank you, yeah. I think personally the ethical safeguards for the surrogate mother are total legal counsel for the surrogate mother from start to end of the journey, that she has independent counsel, psychological counsel, that I suppose that, you know, all the agencies involved in this, and there are, you know, surrogacy agencies that are there to take care of the surrogate mother in many countries, in Canada for example, they have the surrogate mother's interest as the primary interest. The intended parent is, you know, second to the surrogate mother throughout the whole journey. That the surrogate mother has the total control of her own body and pregnancy throughout the whole of the pregnancy, including the decision to terminate. That should be her right. And I think we're in agreement across that. And I think protecting her interests insofar that she does understand from the very beginning, from before any medical or IVF process starts, that everyone is clear and understanding of the agreement, that, you know, she is choosing to carry a child on behalf of a couple, and that couple often will want a lifetime relationship with that woman and the child, not as a parent or a responsibility as a parent, but as someone who's very significant in that child's life. And everyone would want that. And I think the ethical safeguards are those regulated, independent organisations, from lawyers to state agencies to psychological counsel, and that should be done throughout.
Thank you very much. I'm glad you recognise the importance of the birthing mother, you know, particularly for Irish gay dads. It's really important to me that that mother is safeguarded in some way. Thank you.
And just to add